right, that is, the right to be treated fairly, it is no different from the right of any person with a relevant interest who has to see the law applied. And therefore, it denied the application. It denied the appeal to the Privy Council, and in the case of Jackpot, having failed the monetary test and having failed the general public importance test, had seen its appeal denied. So the question is, why doesn't the Attorney General, who is simplifying and streamlining procedure, deem it fit to provide, as of right, the right to appeal to the Privy Council, given that in certain cases of judicial review, there are complex issues. Like in the case of Jackpot, there are many other cases that, therefore, does not, on the face of it, would not allow an appeal to the Privy Council on a question of judicial review if in the case of Jackpot, it concerns the granting of license. The same can be said. The same can be said for others who have applied for a job, etc., and who have appealed by judicial review. The first, Madam Speaker, is the issue of substance, as per the Law Reform Commission paper. And I must say that the Law Reform Commission paper, which is dated 2009, has given a very streamlined, concise, proposed administrative justice bill, stating clearly the grounds for relief. There were a number of grounds: excess of jurisdiction, unauthorized administrative act or omission which was in any way unauthorized or contrary to law, breach of principles of natural justice, unjust, unreasonable, irregular, improper exercise of discretion, abuse of power, fraud, bad faith, all of those which were to be found under one legislation. Because as it stands, under this bill, you will find the procedure now under the Courts Act. You will have to go to case law for substance, and where, according to the Supreme Court rules, the law is silent, you will have to go to England. How is that streamlining it? How is that not creating more of a mess, in fact? So the Law Reform Commission had long pondered, 30 years they've been recommending, therefore, for one umbrella legislation. Similarly, the remedies, Madam Speaker. The remedies which include, I've said it, restitution, compensation, or damages in money, which is not permissible at present under our law. The Supreme Court has disallowed claims for compensatory damages in Mauritius, although it is the case in England. Yet the Law Reform Commission has recommended that. And I would ask the Honourable Attorney General, why does he not think it important now? Since he's bringing an amendment, he's attempting to streamline and clarify judicial review, since it's an opportunity for him to come and once and for all to bring a modern piece of legislation in line with the best practices that other Commonwealth countries have followed, in line with the recommendation of the Law Reform Commission that have long pondered and which is here. Why did it not see merit in doing so? So, Madam Speaker, I think it is a missed opportunity to have a comprehensive law on judicial review. I think that we could have followed the recommendations of the Law Reform Commission again when it comes to the duties imposed on local authorities, on administrative authorities. You will see, Madam Speaker, if you look at the Law Reform Commission paper, you would see that, for example, under Section 14 of the draft, you would have a request for reasons. There would be a duty. An applicant, an aggrieved party, would be entitled to make a request for reasons to an administrative authority, who would have by law, the duty, the obligation to reply. It would have by law to provide a statement of reasons within a prescribed delay, 30 days as from the date of the request. Because what's the point of having a delay if the administrative authority can take months and years to furnish a statement of reasons or to furnish its decision in writing? There was the principle of natural justice enshrined in the draft legislation, that the law relating to natural justice would apply to any person, body, granting, refusing, modifying or revoking any license, permission, qualification, authority, or imposing any penalty under the powers conferred by the enactment. So this is it, Madam Speaker. I'm not inventing anything, it's here. No. It has been here for 30 years. The Prime Minister was Prime Minister then. He was again Prime Minister when they issued the discussion paper in 2009, and he's now Prime Minister again. And yet this this Law Reform Commission paper has all but been wasted. Madam Speaker, to reiterate, what we do need now is a standalone Administrative Justice Act. Yes, codified grounds of review.
Don't repeat.
But I'm just concluding. Codified remedies, statutory duty on administrative authorities to give reasons, statutory timelines imposed on them, a clear right of appeal to the Privy Council, and therefore a modern administrative justice bill. And then, Madam Speaker, I think that the country would be much better. Thank you.
Thank you. Ms. Colette? Qu'est-ce qui se passe là? Est-ce que Mademoiselle Colette peut parler? Elle vous attend là.
Merci beaucoup, Madame la Présidente. Aujourd'hui, c'est mardi, 25 novembre 25. Personne n'accepte d'injustice et de manque de raison. Alors, les exemples du passé nous rappellent pourquoi cette réforme est indispensable, Madame la Présidente. Et nous avons cette demande de refonte du domaine du droit administratif. Nous avons vu des dossiers emblématiques de droit où la clarté des règles s'est perdue dans des délais excessifs. Et il a fallu attendre 5 ans ou plus avant qu'une décision judiciaire ne soit rendue. C'était vu comme normal. Mais nous sommes tous d'accord que ce n'est plus acceptable. Et même à Rodrigue, une région autonome, certaines décisions publiques ont été contestées, mais aboutissant après des années de procès et procédures complexes. Et il me semble que les lenteurs judiciaires touchent toute la République. Ces affaires ne sont pas des anecdotes, Madame la Présidente. Elles sont le miroir d'un système qui laisse trop souvent les citoyens dans l'attente et l'incertitude. Notre justice ne répond plus aux exigences de rapidité, de clarté et de proximité. Mais qu'il soit bien clair, ce n'est pas la faute du judiciaire. Nos juges, nos hommes de loi, notre judiciary staff sont des professionnels hautement formés. Ils travaillent avec rigueur et compétence. Ce sont les procédures trop lourdes et trop anciennes qui freinent leur efficacité. Mais ils donnent de leur mieux. Depuis longtemps, nos concitoyens et même nos juges réclament une justice plus rapide, plus simple, plus proche. Nous n'avons pas été sourds à des réclamations légitimes et raisonnables, exprimées à travers la presse écrite et parlée, exprimées dans les débats publics, exprimées dans les attentes quotidiennes de tous. Aujourd'hui, le moment tant attendu est enfin arrivé. Ce projet de loi est la réponse directe aux attentes du peuple, des law practitioners, ainsi que du judiciaire. Et j'abonde dans le sens des interventions de l'Attorney General et de mon collègue l'honorable Siebel. Avec votre indulgence, Madame la Présidente, je souhaite mettre en contexte le projet de loi. C'est un projet qui modifie la Courts Act pour simplifier et rationaliser la procédure de révision judiciaire et non une refonte du fond du droit administratif qui, je pense, évolue au cas par cas. Ce projet de loi introduit une nouvelle sous-partie subpart 6A qui encadre clairement les étapes. La demande de livre doit être déposée dans un délai de 45 jours. Elle doit être complète avec affidavit, pièces justificatives et motifs précis. Et le juge en chambre peut décider d'un stay, c'est-à-dire suspendre la décision administrative contestée. Et le juge doit statuer dans un délai maximum de 60 jours. Et en cas de refus de livre, un appel est possible devant la Cour suprême. Une fois le livre accordé, la demande devient directement une révision judiciaire et il n'y a plus de doublons. Mais qu'est-ce que la justice, Madame la Présidente? La justice, c'est l'équilibre entre les droits et les devoirs. C'est l'institution qui protège le faible face au fort. C'est la garantie que chacun est traité avec équité, selon la loi, sans privilège ni discrimination. La justice, c'est le socle de notre démocratie et sans justice, il n'y a pas de liberté véritable. Sans justice, il n'y a pas de confiance dans l'État. Et la révision judiciaire est l'outil qui incarne cette justice. Elle ne juge pas si une décision est bonne ou mauvaise, mais elle juge si elle est légale et juste. Et c'est la garantie que personne n'est au-dessus de la loi, ni même l'administration. Je pense que la procédure révisée est maintenant plus cohérente. Quand nous parlons d'administration, nous parlons de tous les services publics, ministères, l'Assemblée régionale de Rodrigue, qui agit au nom et pour le compte du gouvernement central, les collectivités locales, les établissements publics comme les hôpitaux ou les universités, et même les organismes chargés d'une mission de service public. Tous devront savoir que leurs décisions peuvent être contrôlées vite et efficacement. Ce projet de loi, Madame la Présidente, harmonise la révision judiciaire dans toutes les sphères de la vie publique. Il touche la santé, la finance, l'économie, les médias, la propriété intellectuelle, la fiscalité, l'agriculture, le transport, les professions réglementées et même les sanctions internationales. Ainsi, il prévoit, entre autres, que les décisions, par exemple, du Registrar of Businesses, du Tribunal des relations de travail, pourront être contestées par révision judiciaire. Les décisions du Financial Crimes Commission, de l'Independent Broadcasting Authority seront désormais révisables. Les professions réglementées, architectes, géomètres, quantity surveyors, vétérinaires, auront accès à la révision judiciaire en cas de refus d'enregistrement ou de sanctions disciplinaires. Et les décisions du Public Bodies Appeal Tribunal, de la National Land Transport Authority seront aussi soumises à la révision judiciaire. Enfin, Madame la Présidente, ce projet de loi est un signal fort. L'État n'a pas peur d'être contrôlé. Il choisit la transparence, il choisit l'efficacité et il place le citoyen au centre. Ce projet de loi incarne une justice moderne, une justice de confiance, une justice au service du peuple. Et je remercie l'équipe du bureau de l'Attorney General ainsi que l'Attorney General pour leur écoute et réactivité aux défis du monde moderne dans notre République. Et je soutiens ce projet de loi. Je vous remercie, Madame la Présidente.
Merci beaucoup. Short, nice and sweet. Thank you. Mr. Honourable Pentia. May I just ask if I'm mistaken? I heard something about the date of notification and the date when the decision is taken. Even under this law, the date of notification counts. Just to make things clear.
Madam,
even the 21 days.
Yes, Madam Speaker, I thought it was obvious to everyone,
Of
but
course.
similarly, it seems that it is not obvious. So I will address the issue later on.
Yeah, I've been 10 years in PBAT, so I know. Mr. Pentia.
But your point is to clarify. Make it obvious.
Mais c'est clair, c'est évident. C'est déjà la loi.
Madam Speaker, I was going to say at the very outset, with your permission, that I was blessed that both members of the opposition were present for a change. Then one just walked out. But then again, I'm honored to have at least one member of the opposition at this hour of work is still in the House. Madam Speaker, to address two things. Concerning the notification, the Attorney General will duly address, but concerning clarity on grounds and clarity on remedy, two issues raised during the intervention of the honourable member of opposition. Well, grounds and remedy are clear for judicial review. This is an ABC of law of judicial review. And, Madam Speaker, shall I start? I start my intervention with a quote from Montesquieu, the architect of the doctrine of separation of powers, who wrote the spirit of laws, and I quote, "There is no cruel tyranny than that which is perpetuated under the shield of law and in the name of justice." End of quote. Madam Speaker, these powerful words capture the very spirit of what we are debating today. Already, the 28th bill of this year. This bill is about preserving one of the most fundamental pillars of our democracy, the right of every citizen of this country to challenge, by way of judicial review, the decisions of the executive and of public authorities. Indeed, judicial review is a living expression of Montesquieu's doctrine of separation of powers. It is a means through which the judiciary ensures that the executive remains within the parameters of the law and that decisions taken by those in power are lawful, reasonable, and fair. Madam Speaker, this bill is a safeguard that ensures that power does not turn into tyranny, that authority is exercised with accountability, and that justice remains within the reach of the people to seek redress where applicable. Our Constitution enshrines this safeguard, first and foremost, in clear and noble terms. Section 3 guarantees to every citizen the protection of the law, a phrase that has long been interpreted by our courts to include the right to seek justice and to challenge unlawful administrative action. Section 17 of our Constitution provides that when a person alleges that his fundamental rights have been, are being, or are likely to be contravened, he may apply directly to the Supreme Court for redress. Section 17, subsection 2 of our Constitution vests the Supreme Court with the jurisdiction to make such orders, issue such writs, and give such directions as it may consider appropriate, including the very prerogative remedies that form the heart of judicial review, such as certiorari, mandamus, prohibition, or declaration. These provisions together give life to the principle that justice must always remain accessible, enforceable, and impartial. Judicial review, Madam Speaker, is therefore not a mere procedural tool. It is also a constitutional right guaranteed to every Mauritian. History has shown, Madam Speaker, that whenever the executive acts without proper checks and balances, the rule of law is fettered and public confidence in institutions erode. The previous government, having sown the seeds of unfairness and disregard for due process, tasted the bitter taste of the fruit of their own poison at the last general elections. That is why this amendment to streamline the judicial review process assumes all its importance. It ensures that the mistakes of the past cannot be repeated, that power is subject to the discipline of law, and that fairness and accountability are restored at the heart of governance. The executive must govern, yes, but it must do so within the limits of law and under the scrutiny of justice. The previous government on too many occasions acted in ways that defied the principles of fairness, procedural propriety, and impartiality. Appointments and promotions were influenced. Disciplinary actions were taken without the right to be heard, and decisions were marked by bias and procedural irregularities. Many of these were decisions amenable to judicial review. But the reality is that for many citizens, that truth was simply out of reach. Not because justice was unavailable, but because it was unaffordable, intimidating, and painfully slow. As Minister of the Public Service and Administrative Reforms, I have met countless officers who have suffered in silence. Dedicated men and women who were unfairly bypassed for appointment or promotion. Officers who met every qualification, who had the experience, the dedication, and the integrity, yet were overlooked without explanation. When asked, very often the reply was, "I couldn't afford it." Some even silently added, "I was afraid of retribution by the tyranny of those in power." Mr. Speaker, time is money. This adage could not be more true than in this context. The longer the process, the higher the cost, to such an extent that judicial review runs the risk to be the privilege of the few, when it should be a right of all. I have even known cases where public officers who had the courage to bring the cases to court saw their proceedings drag on for so long that they retired before judgment was delivered. And in some tragic instances, they passed away before justice could be served. Those cases were struck off as no longer live matters. But, Madam Speaker, for the victims and their families, then justice lives on. It is therefore with deep satisfaction that I welcome the Court's Amendment Bill, number 28 of 2025, brought before this House by the Attorney General. This bill is a tuning point. It's a turning point. It brings a long-awaited reform to the judicial review process, a reform that will make the system faster, simpler, and fairer. For many of our citizens, including public officers, there is now light at the end of the tunnel. Judicial review will no longer be the privilege of the few, but a right within the reach of all. The problem we are addressing through this bill is well known. The current process of judicial review has become too lengthy, too costly, and often not accessible. What we endeavor as a responsible government, and what this bill delivers, is a streamlined process that reduces time and cost, simplifies access, and ensures that citizens can challenge unfair administrative decisions without being overwhelmed by complexity or delay. The first stage, the test of arguability, where the court decides whether the applicant has an arguable case with a reasonable prospect of success. The second stage, i.e., the substantive hearing, where the case is fully heard and the court decides whether the public body acted lawfully, fairly, and rationally. Madam Speaker, in practice, as we have said, the first stage has become unnecessarily complicated. Hearings are often conducted in open court. Oral submissions are made. Affidavits are exchanged. And in most cases, two or more judges sit to deliver a written judgment, sometimes many months later at the very first leave stage. This is time-consuming. This is costly, and contrary to the very purpose of the leave stage, which is meant only as a preliminary filter. As noted in the case of Moit against the DPP, 2006, UKPC number 20, and echoed in several Supreme Court judgments. The levy stage should be determined on a cursory glance at the material to decide whether there is an arguable case. And yet, the levy stage has become a trial before a trial. A trial before the trial. That is what this bill seeks to correct. Under the new Subpart 6A of the Courts Act, the judicial review process will now be modern, efficient, accessible. First, the time limit from 90 days to 45 days, encouraging prompt action and certainty. Second, the judge in chambers will determine the application inter partes on the papers alone, without open court hearings, except in exceptional circumstances. Here again, the discretion of the court is preserved. Third, the judge must deliver a decision within 60 days, bringing long-awaited timeliness to the process. Fourth, where leave is granted, the same application stands at the substantive hearing, avoiding duplication and saving time. Finally, where leave is refused, an appeal can now be made to the Supreme Court and the Civil Appeal Act 2025, instead to the Privy Council. Perhaps the honourable member of the opposition read this part instead of proposing that we should go to the Privy Council. Madam Speaker, these reforms transform judicial review from a distant, costly procedure into a fair, efficient, and accessible remedy for the people. With this bill, Mauritius stands alongside many other jurisdictions, embracing a modern and citizen-centered model of administrative justice. The Courts Amendment Bill 2025 is more than a procedural reform. It is a reaffirmation of our constitutional values of fairness and accountability, of reaffirming that this is a land where the rule of law prevails. This bill says to every Mauritian, justice will no longer depend on wealth or endurance. It will depend on right and reason. With this bill, the government is making justice affordable, swift and fair. We are ensuring that those aggrieved by decisions of public bodies suffer at least the least possible prejudice. And we are fulfilling our solemn duty as a caring and responsible government, that justice must not only be done, as rightly said by the Attorney General, it must be seen to be done. At the pace at which our justice system is being reformed, I have no doubt, Madam Speaker, that Mauritius will soon stand as a model democracy, a nation where the rule of law will again prevail, where justice is within the reach of every citizen, and where our democratic values are not merely proclaimed, but lived. Madam Speaker, I shall conclude with the very words of Lord Denning, affectionately remembered as a people's judge. He propounded, if the citizen is to have confidence in the law, he must be able to challenge the acts of the executive without fear or excessive cost. Justice must be open to all. End of quote. Madam Speaker, this is a promise of this government. This is a path to a fairer Mauritius. With these words, I recommend the bill to the House. Thank you.
Yes, Honourable Minister of Labour.
Madam Speaker, the bill before this House is part of a series of bills that have been introduced in Parliament since the beginning of the year to improve access to justice and ensure a speedier and more effective dispute resolution mechanism. This is in line with the government's commitment, as announced in the presidential address earlier in January, to introduce reforms to ensure that the judicial and legal system operate more efficiently, swiftly, fairly, and make justice more accessible. I'm not going to set out the long list of amendments that has been brought to various legislation, ranging from the Financial Crimes Commission through the new Revenue Tribunal Act, and then the amendments to the Criminal Appeal and Criminal Review Act and the Civil Appeal Act. Suffices to say, Madam Speaker, that I would like to put on record the brilliant work done by the Honourable Attorney General and his team at the State Law Office to pilot these reforms. As a leading senior counsel, the Honourable Attorney General has first-hand experience of the hurdles and procedural rigidities which all too often result in lengthy and costly proceeding, abuse of process, and denial of justice. Madam Speaker, the object of this bill is to simplify and streamline the procedure for an application for judicial review. Now, as has been aptly stated by the Honourable Attorney General, judicial review is the fundamental means by which the judiciary calls the executive and the public bodies to account and make sure that they exercise their authority within the limits of the powers and remain accountable under the rule of law. Judicial review is an important component of the check and balances enshrined in our Constitution. For example, if a citizen has applied for a license and has not received his license, usually he will go by way of judicial review to review the decision of the minister. Similarly, if he has been denied a license by the local authorities, he will usually go by way of judicial review. For certain appointment by Local Government Service Commission and PSC, again, the remedy would be to go by way of judicial review. Now, I'm very surprised by what the Honourable Adrien Duval stated. He started by stating that we have, the Honourable Attorney General, missed an opportunity to review the substantive law, and he relies on the Law Commission, the Law Reform Commission. I have a quick glance at the Law Reform Commission discussion paper on judicial review, published in November 2009, which annexes a draft administrative justice bill, which was borrowed from the Barbados administrative justice bill. And I've gone through the grounds, which is set out in section 5 of that draft bill, and I'm sorry, but all of the grounds that are set out in that act is already grounds for our senior judicial review to the court. So the act only codified what exists in our law. So what is the point of putting restrictions on the judiciary for grounds under which they can review an administrative decision? Because there may be in the future other grounds that may be developed through judicial pronouncement. So I don't think that there is any reason why this legislation should curtail the right of the judiciary when it comes to the grounds on which to review administrative decision. Similarly, when I look at the remedies provided in that draft legislation, these are already remedies that are applied consistently by the courts in Mauritius. Now, the only nuance on what Honourable Adrien Duval said is about damages. Oh, yeah. But again, damages in exceptional circumstances is awarded in England, and I'm sure in cases which befitted an award of damages, which is quite exceptional because judicial review by its nature itself concern the review of the decision-making process as opposed to the decision itself. So it would be extremely rare that in the case of judicial review, the court would award a monetary compensation. But what I found even more shocking is that the honorable gentleman who chose not to be here when we replied to his, the honorable member who chose not to be present when we replied to his address, he started by saying that the Honorable Attorney General adopted to, and I quote, a complex procedural system. And in fact, it is complete opposite, Madam Speaker. It is the complete opposite. This bill is going to substantially simplify matters as when it comes to judicial review. As the Attorney General mentioned, we have two steps when it comes to judicial review. First, the citizen, the aggrieved party, must apply for leave to bring judicial review. This is the first stage, the leave stage. And then once he has been granted the leave, then he goes to the second stage, which is the main part of the judicial review, where the decision on the merit is considered and determined. Now, there is a fair amount of confusion as to what happened at leave stage. At leave stage, what should really happen is that the court should only determine on a quick perusal of the material available if there is an arguable case with a realistic prospect of success. A very low threshold. At the leave stage, the court may dismiss applications which are frivolous, vexatious, or hopeless. So at leave stage is really the role of the judiciary is to act as a filter and throw away all those unmeritorious cases, ex facie, the documents, the evidence produced. Now, what happened in reality, in practice, unfortunately, depending on the lawyers, there are extensive exchanges of affidavit and counter-affidavit and preliminary point and objection, and just on the leave stage, the procedure drags on for weeks and for weeks. And this results necessarily in denial of justice. So what is the Attorney General doing with this bill? First of all, the procedure before leave. At the moment, we have to go before 2 judges, and that takes time. This is being replaced. Leave stage, you go to a judging chambers. Judging chambers usually have jurisdiction when you have to expedite matters. When there are matters which call for prompt decision, you go to a judging chamber. And obviously, it's easier for a judge sitting alone to decide on an application than 2 judges sitting in open court. Second procedure that is being simplified. Everything has to be in your affidavit, in your written material in front of the judging chambers. Exceptionally, the judge can ask for written submission. And even more exceptionally, he can ask for oral submission. So in practice, this is bound to be a speedier process than it is today. But to ensure that it is a speedier process, the Honorable Attorney General has inserted a clause which imposes a time limit within which the Honorable Judge must give its determination, and that is 60 days from the close of pleading, from the close of the hearing, if there is a hearing. And the bill goes even further, and you can even complain to the Chief Justice if the judging chamber missed that first 60 days delay. The second way where we are simplifying the system and bringing certainty is the delay within which you can apply for judicial review. And here I completely don't connect with your honorable member, who is a barrister. So he is supposed to know the law. I can understand many lay people here, members here, who are not well versed in law, who can make a comment as stupid as saying that the time limit to bring judicial proceeding is 3 months, and now you're reducing it to only 45 days. But there's a long list of cases, Madam Speaker, where the court has systematically held that the 3 months delay is not the applicable, the applicable criteria. Applicable criteria is promptness. You need to promptly bring an application for judicial review. And this is where we have a problem, because the court are inconsistent when it comes to determining what amounts to promptness. Is it 6 weeks? Is it a month? Is it 2 months? Is it 21 days? There has been consistently, contradictory judgment. And not only at the level of the Supreme Court, but all the way to the Privy Council. And in the Privy Council, in at least 2 decisions, the law lords restated the rule. The rule is that you have to bring judicial review as promptly as possible, and what is prompt will depend on a case-by-case basis, depending on the facts and depending on the explanation given by the applicant for the delay, if any, to bring proceedings. That what we are doing today is removing this uncertainty as to what amount to promptness. We are saying in the law, 45 days. That's it. Now there is certainty. Everybody knows that you have to apply for judicial review within 45 days of a decision. And what we're doing, in Section 4, we're amending all the laws, a series of laws, which had contradictory delays for applying for judicial review. There are some decisions which require you to do judicial review within 21 days. There are some statutes which require judicial review to be lodged within 28 days. There are some statutes which doesn't even provide a statutory duty. Just tell you, you can appeal by way of judicial review against the administrative decision. So we're bringing certainty now, whether it is an appeal against a decision of the Public Bodies Appeal Tribunal, whether it is an appeal against a decision of the Mauritian Revenue Authority, all appeal by way of judicial review today will have to be lodged within 45 days. Now, how can that be a problem? How can that be disputed? How can that be creating uncertainty or penalizing the applicant? So that is why I simply come to understand a barrister telling you that when we produce certainty by giving a time frame, this will necessarily be something bad. The 60-day delay. Why is it important? It is important, Madam Speaker, because I'll give you an example of a case that the judgment had just been given this year, and that relates to a lecturer who had decided to appeal against a decision of the University of Mauritius. And in that case, the application for leave for judicial review was lodged in February 2018. February 2018. Judgment on leave stage, I'm not talking about the second stage, on leave stage was delivered on the 9th September 2025, 2 months ago. Wow. That is 7 years. And by the time the judges gave their decision, there was no live issue. There was no live issue because the poor applicant had retired and the question of giving him a promotion was no longer a live issue. So this is the type of abuse that we're trying to meet today by bringing this time limit of 60 days in order for judges to give their decision. The other very important amendment that is being brought, Madam Speaker, is in Section 70, the new Section 76H, which deals with the second leg. Now, as the law stands today, after having gone through the process of leave, after having obtained leave, you have to start from scratch again. The applicant has to swear a new affidavit, annex a new series of documents, and produce it. And sometimes you have boxes of pleadings that is being thrown to the judges. Duplicity in materials. So now what we're saying in this new law, that if the judging chambers ex facie of the pleading sees that you have a good arguable case that deserves to go to the next stage, you don't need to file a new set of affidavit. This affidavit, these documents that have been filed with the judging chambers, in first instance, in the leg stage, this would be the basis for the second stage, for the stage where the judges will consider the application on the merit. And again, I don't understand the honorable member. He says that, we should have put the right to appeal to the Privy Council. This is why we have the decision heard by 2 judges, so that precisely you can apply to the Judicial Committee of the Privy Council. And he thinks that it is not constitutional, it's not as of right. Let me just read the first sentence of the judgment in the case of Siker, in which my learned friends appeared. Siker against the Employment Relation Tribunal. First line. This is an appeal as of right from a decision of the Supreme Court of Mauritius, which refused the appellant leave to apply for judicial review. So what is he talking about? It's already in the law. And in any event, the Judicial Committee of the Privy Council always have the discretion to entertain an application to be heard before him, even if the Supreme Court has denied the applicant the right to appeal to the Privy Council. So, Madam Speaker, as I said, I'm very sad that, yes, the other thing he mentioned is that we need to bring a law so that all administrative bodies are bound to give reasoned further decision. Again, as a lawyer, he ought to know if a person is aggrieved because he had a legitimate expectation to be informed of a decision, he had a legitimate expectation to be consulted, or if a public body has abused its right, has acted abusively, abus de droit, these are grounds for judicial review. You don't have to set it out in the law. Already it is a ground to appeal, to apply for judicial review. So there's absolutely no reason to go and amend all possible legislation and say that an administrative body has to give a decision every time he is required to make a decision. All we know, it's already in the civil code. Whenever a body, an authority is given a discretion, they need to exercise this discretion in good faith. It's already in the law. There's no need to change the law. So, Madam Speaker, I hope I have replied to the various grounds raised by the honourable member. I congratulate again the Attorney General and his team at the State Law Office to bring this piece of legislation, which no doubt is going to simplify the application for judicial review and ensure a speedier resolution of dispute. Thank you, Madam Speaker.
Thank you, Minister. The winding up speech, yes, Attorney General.
You keep saying that I wind up people at the end of my speeches,
So
Madam
you
Speaker.
don't like winding up.
I was just wondering when my learned colleagues were actually making reference to the other side of the House, that I am becoming very adept and almost a champion now at shadow boxing, because I do not have an opponent to face me when he needs to face me. I'm very grateful to the Honourable Ting for his extremely comprehensive tutorial on the law. I have not had the time to do it in my speech, and he has done it as he usually does. I'm also very grateful to Honourable Seaburn, Colette and Pendia for their speeches on this bill. Now, since Honourable Team has been complete in his address to the House, let me just address a couple of matters that really defeats completely my comprehension and understanding of the law. It is absolutely true and certain that my aim, the aim of this new bill, was not to change the substance of the law relating to judicial review. He is right, Mr. Duval, the honourable member, that to say that I've not done so, and I restricted my intervention on the procedural aspects for one very good reason, which was touched upon by Honourable Colette in a speech. The aim was to amend the processes so that we address the very immediate problem, which is delay and accessibility. C'est un choix délibéré, c'est une simplification et non une refonte. Now, the point that the Honourable Duval makes in relation to the notification issue, which brought a wry smile to your face, Madam Speaker, is again because he has failed to read everything in the bill. Now, if he had gone to clause 4, the consequential amendments, and the various acts of Parliament which are being amended to put them in line with what we propose in this amendment to the Courts Act, he will see that in every single subpart of clause 4, 1, 2, 3, 4 and following, that the words used in the enabling legislation which gave the right to the public body to take a decision, let's take the first one, which is the Allied Health Professional Council Act, where it is said that it is amended by repealing section 37 and replacing by the following section: review of decision of council, a person who is aggrieved by a decision of the council. Now, how can you be aggrieved if you do not know of the decision? How can you, if one goes to the next one, which is the Bank of Mauritius Act, how can you say that you're dissatisfied with the determination of the review panel if you're not aware of the decision or the review panel? I can go on and on for another 30 minutes, but I'm obviously not going to bore this House with more nonsensical matters. Now, Honourable Utim has also dealt on the 45 days issue, and I said it in my speech and I'll repeat it so that it's very clear. There have been many decisions deciding on what is an application which has been done with the promptness required by the law. Some legislation provide for 21 days, some 28 days, but some do not provide it. And in the Seacare case, referred to earlier on, 42 days was decided not to be prompt enough. And when we know that erstwhile in the old days, 3 months was kind of the yardstick, it was decided, and I said it in my speech, that 45 days would be, as one can say, we middle the diddle. We go 45 days, which is half of 3 months, so that we give ample time to the persons dissatisfied with a decision to start judicial review proceedings. Now, Madam Speaker, building a bridge to the future, which is the aim of this government, means to pause and reassess the workings of our institutions with clarity and honesty. We must ask ourselves whether they still serve the public with the efficiency, fairness and transparency that the mature democracy requires. The reform before us, though technical in appearance, touches on principles that define who we are as a nation. This bill does not touch the substance of judicial oversight developed by our case law over decades. Instead, it simply modernizes the procedure through which that oversight is exercised. These reforms do not encroach upon judicial independence. They reinforce it by giving the courts the procedural structure they themselves have long called for. They reduce unnecessary formalism and allow judges to devote their time to what truly matters, the substance of the challenge. Finally, Madam Speaker, this bill, in fact, restores trust in the system. It protects both the individual and the administration by ensuring that legality is determined without unnecessary delay. It reaffirms that in Mauritius, the rule of law is not an abstract idea, but a living principle. With these words, I commend the bill to the House.
Yes. I need someone to second, please. Again, Mr. Pentia. Okay, the question is that the Court's Amendment Bill, number 28 of 2025, be read a second time. Those in favour say aye. Those against say no. The ayes have it.
Committee stage.
Clause 1, short title. Clause 2, interpretation. Clause 3, part 2, principal act amended. Clause 4, consequential amendments. Clause 5, commencement.
The question is that clauses 1 to 5 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Title and enacting clause.
Yes, the question is that the title and enacting clause stand part of the bill. Those in favour say aye. Those against say no. I would love to see more ayes, or not, I don't know. The ayes have it. Final question. Question is that I do report to the House that the Court's Amendment Bill, number 28 of 2025, has passed the committee stage without amendment. Those in favour say aye. Aye. Those against say no. The ayes have it. I will resume my chair. Honourable members, I have to report to the House that the Court's Amendment Bill, number 28 of 2025, has passed the committee stage without amendment.
Third reading.
Madam Speaker, I move that the Court's Amendment Bill number 28 of 2025 be read and third time and passed.
Seconded. Thank you. The question is that the Court's Amendment Bill, number 28 of 2025, be read a third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it. Adjournment.
Madam Speaker, I beg to move for the adjournment of the House to Tuesday, the 2nd of December at 11:30 a.m.
The House stands adjourned.